Your surgeon left a sponge inside you and called it a souvenir, except nobody's laughing, especially not you. That kind of mistake is not just bad luck, it is something the law actually has a name for, and that name is malpractice. You might think doctors are basically magicians who never mess up, but spoiler alert, they are humans wearing very expensive coats. Misdiagnosis happens way more than people realize, and sometimes it means you got treated for the wrong thing while the real problem kept growing quietly in the background. Here's the part that surprises people: you cannot sue someone just because you are unhappy with your results. The law needs proof that the doctor did something a reasonably careful doctor would not have done, which sounds like a riddle, but it basically means they messed up in a way that broke the rules of their own profession. Think of it like a recipe. If a chef forgets the salt, your dinner is just bland, but if a surgeon forgets to check your chart and operates on the wrong knee, that is a whole different level of oops. The legal word for that second kind of mistake is negligence, and negligence is the engine that makes a malpractice case move forward. You also need something called damages, which is a fancy way of saying you actually got hurt because of the mistake. If the misdiagnosis delayed your treatment and your condition got worse, that delay itself can count as real harm, even if you eventually got the correct diagnosis later. Doubt usually creeps in here because people assume hospitals are untouchable fortresses protected by lawyers in shiny armor. They do have lawyers, sure, but that does not mean you have no shot, it just means you need real evidence instead of just a bad feeling. Evidence in these cases usually means medical records, expert opinions, and a timeline that shows what should have happened versus what actually happened. It is less like a courtroom drama and more like assembling a very serious puzzle where every piece has to fit perfectly. A lot of people wait too long to ask questions, thinking time will smooth things over like a movie montage. Each state has a deadline called a statute of limitations, and once that clock runs out, your chance to file a claim disappears no matter how strong your story is. You might also hear the phrase standard of care, which sounds like something you'd find on a fancy spa menu. In reality, it just means the basic level of skill and attention any competent doctor in that situation should provide. Here's a twist nobody warned you about. Sometimes the mistake is not the doctor at all, it is a miscommunication between departments, like a lab sending the wrong results or a nurse misreading dosage instructions. That is why these cases sometimes involve more than one person, or even the hospital itself as an organization. People often confuse a bad outcome with a bad doctor, but medicine has uncertainty built into it like static on an old television. Sometimes treatments fail even when everything was done correctly, and the law tries to separate honest limitations of medicine from actual carelessness. This is exactly why talking to an accident injury lawyer early matters more than people expect. They help you figure out whether your situation crosses that line from unfortunate to legally actionable, kind of like a translator between medical jargon and real-world consequences. Preparation is the secret weapon here, not panic. Save your records, write down your timeline while it is fresh, and get a professional opinion before assuming nothing can be done. You deserve answers, not guesses, especially when your health was on the line. Mistakes happen, but accountability still matters, and knowing your rights is the first step toward making sure your story does not end in silence. If you want to learn more about how this works for your own situation, check out our links in the description below.